Leave applications rarely succeed. Is there a method to this madness? Nothing terrifies a senior lawyer like an application for leave to appeal to the federal court. Of the 1,000 applications filed, usually 100 survive. 900 fail. Most applications are lost even before the hearing day. And I think it's because of bad technique. Now, technique is as important, if not more important, than other skills. Now, technique is a transferable skill. That's the purpose of this article. The first thing I would want to emphasize is basic law. You must take the trouble to understand the basics. Now, under Section 96 of the Courts of Judicature Act 1964, an appeal lies from the Court of Appeal to the federal court, but it's not automatic. The federal court can only be accessed with leave, meaning permission of the federal court. Now, you have to satisfy the federal court that your application falls within one of two limbs. It's exceedingly crucial that you listen to these two limbs. The first is that it involves a question of general importance decided for the first time or called the first limb, and second, that it's a question of importance upon which further argument and decision of the federal court would be to public advantage, and that's called the second limb. Are there special techniques to drafting leave questions? The answer is yes. Here are some essential pointers. I've got about 25 of them, so I need to be a little fast in this video. Bear with me, please. Tip number 1, understand the nuances of two federal court cases inside out. The first, Terengganu Forest Products versus COSCO Container Lines. The second one is Datuk Syed, Kechik Syed Mohamed versus the Board of Trustees of the Sabah Foundation. If you have read them once, read them again. Of the two, I think Syed Kechik is all poetry, but Terengganu Forest Products is the latest. There, the federal court sets out a series of principles. I have analyzed them and I found 5. Try and commit them to memory. The first principle is ensure that the case started in the High Court. So if you have a case that started in the Sessions Court, you can't use Section 96. The second thing you must satisfy is that the application concerns a decision made by the Court of Appeal, but it must arise from the High Court in the exercise of its original jurisdiction. The third tip is understand what would be fatal to your application. There are circumstances when the court will not grant leave at all. And here are the circumstances where it will not do that. The first is it will not grant leave in interlocutory appeals. In Terengganu Forest Products, the federal court said, referring to Order 14 and Order 18 Rule 19, that more than 60 interlocutory orders which are normally discretionary in nature should be left to the trial judge to decide. They are not final. Such cases should just go on for trial. So if you are going to the federal court on one of those 60 over orders from the High Court, don't bother. The second point you need to remember is where the question is abstract, academic, or hypothetical, you will not get leave. You will not get leave. The third is where neither party is interested in the outcome of the appeal. Remember, the Bar Council filed an application against the Chief Justice and the President of the Court of Appeal last year. The federal court said it was an academic question and declined to answer it. The final area where the court will not interfere is a first impression. The federal court looks at the record of appeal and says, I think this case is going to be inevitably a failure. And then in those cases, they will not give you leave. The fourth tip I would like to give you is the if-then category, or it's a conditional question. Let me give you an example. And the question itself is quite long. Bear with me. Here's the question. Whether, when, in interpreting a general release or a clause in an agreement containing a general release, it is ever permissible in law to take a literal rather than a contextual interpretation of the same. by ignoring circumstances of the factual background known to the parties at or before the date of the release. Blah, 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 so many words, 54 words. By the time I got into the third line, I was lost. Now, if you're going to ask questions like that, you're not going to go anywhere. Do you understand the question and example 4? It's a conditional question. It is fact-based. It says so. It's also hypothetical. And it's vague. Miraculously, the applicant obtained leave. But at the substantive hearing, the federal court simply said it will not answer the question. This really happened. Let me move on to the 5th tip. Tip number 5. Leave will not be granted for statutory interpretation if 2 conditions exist. First, where interpreting a statute, the Court of Appeal interpreted it in a way that was so obviously right, then the federal court has no choice but uphold the Court of Appeal's decision. So don't ask federal court leave for statutory interpretation issues where the words are unambiguous and they are clear. The next one is what I call a particular fact situation. This is where the interpretation of a statutory provision is relevant only to the particular set of circumstances relevant to that case. And the chances are a situation like that is not likely to recur. It doesn't affect the general commercial nature of any question in the country or any particular state. If those are the circumstances, don't even go there. Avoid drafting questions that fall into this category. Tip number 6. This is the no leave unless category, where there is also statutory and contractual interpretation. The 5th principle is only marginally less fatal than the earlier one that I spoke to you about. Now, in Terengganu Forest Products, the court said leave will not be granted unless it is of public importance. So, it said leave will not be granted on questions that ask to interpret statutes unless it is shown that it's of public importance. So I'm going to give you 2 examples in examples 5 and 10. Hold on a few minutes. I will demonstrate it in a few minutes. Pay attention to examples 5 and 10. The second point I want to make right now is leave will not be granted on questions that ask for construction of contracts unless that contractual clause benefits that trade or industry. I've got a question in example 8, which is a fire insurance question, which is of this type. I'll show you to shortly. So avoid that trap. So now I move on to tip number 7. Here is the secret. The second limb under section 96 is easier to succeed than the first limb. So choose the second limb any day. The first limb is more difficult to overcome because you have the terrible burden of proving that your question that turns on matters decided by the Court of Appeal for the first time. Second, that it has never been decided by the federal court and no one has ever thought of this question. Now all your opponent has to do is to pull out a federal court case that bears some resemblance to your question and you're out. 3 strikes. Gone. It's an impossible 75 inclined climb. Chances of success are about 3%. Don't bother with it. I move on now to the 8th tip. The second limb, which I said is easier, there is one strict limitation that you have to overcome. And that is you have to show that the second limb question is to the public advantage. So now let's move on to the 9th tip. If you have no choice, you can't do a second limb question and you're forced to do a first limb question, then you must explain the general principle carefully. Not in your written submissions, but in your affidavit, and you must explain why it is a matter of general principle, and secondly, you must explain why it's important to the public interest. Merely simply saying in your affidavit, this is a general question, it's important to the public, that won't cut it. Go further. Show yours is 1 in 1,000 case. Show that your decision made by the federal court on that question will impact the general law in a major way. Do some factual background, do some research, show some facts, show some statistics, show some figures. Take, for example, a fire insurance claim. I'm going to give you a fictitious example, but this is what I might say. That of the 2 billion ringgit worth of assets lost every year to fire, claims in the range of 1.5 billion are never indemnified because there is a confusion in this area of law. So don't just say that the question has a major impact on the insurance industry. Show how other jurisdictions have dealt with the problem and why it is to the public advantage. Show why the answer to your question matters to commerce, to industry, to insurance. Then ask the federal court to intervene and dispel this mist, this miasma of uncertainty for the benefit of the business community. Then they may be interested. Tip number 10 is, you are appealing against a decision of the Court of Appeal. Locate the pivotal passage that shows there is an error. Now, if you are dealing with the Court of Appeal decision, take particular care over the 3-pronged strict requirements of the first limb. Show in the judgment where the Court of Appeal was referring to. Show where that question arose. Show the law surrounding that area in that passage. If you can't find the pivotal passage in the Court of Appeal grounds, you will fail. But there is a way of getting out of it. What you must tell the federal court is, the point was so important that the Court of Appeal missed it altogether, that there was an omission, and that the omission was so grave and vastly important, that was the source of error central to the leave application. Now, the omission point is as important as the manifest error point. Then show that the question posed is coming up for the first time before the federal court, that no federal court has ever dealt with it before, and finally show why it's of general importance. About 75% of the applicants fail at this point. Tip number 11. Please do not argue that the answer to the question will solve your problem. The question should suggest that there is a crucial point of law that requires further argument. If you say that the answer is important to do justice to the parties, that's completely irrelevant. Don't say, if you don't answer the question, my client will suffer these blood and gore arguments. All that won't pass muster. So do not speak of the hardship faced by the parties, or how she or he or the company will come to grief because of the double-barrel mistakes in the High Court and the Court of Appeal. That is an accepted risk of litigation. The courts in the United Kingdom, Australia, New Zealand and India have said that's not a reason for granting leave. Our position is the same as all those jurisdictions. The court is looking for what it's thinking about as the national interest point. Show that the federal court's answer to your question will be to the advantage of the public. The 12th point I wish to make is deep research. Read as widely as you can on the law surrounding the question. Start with the latest textbook on the subject. Then go to the All England annual reports. The quarterly law review is no pushover either. To this, I would add 2 more sources. One is internet articles on those issues, and You may be surprised, the Indian Supreme Court reports. Those guys over there have rehearsed more law, more times than any one of us. And for goodness sake, pay a small sum of money to the local university library and become a member so that you can have access to a wide range of scholarly articles and books. The 13th tip, don't start your question with the words whether. It's called the folly of the whether question. We've all had problems in the Commonwealth in that we've all been taught to frame any question of law with the word whether. It's a widely followed, outdated and useless convention. The quicker you avoid it, the better it is. Not all questions of law fit into this whether formula. The American lawyers, for example, abhor this. Brian Garner is a brilliant lawyer and a brilliant writer, and he wrote a book which became a runaway success. It's called The Winning Brief. Most of the materials that I have gathered in this article are from that book. Please get it. The older book used to be thin and green. Now it's quite thick and it's totally brilliant the way he writes it. He says, don't start with whether or any other interrogative word because it's ghastly in its usual form. He says this. Tip number 14. Clarity. Conversely, vague questions fail. Make the question as clear as possible. The best argument on a question of law is to state the question clearly. You know, Lord Denning said, woolly thinking produces woolly writing. If you're thinking clearly, your question will be clear. In the law, the right answer usually depends on putting the right question. You get your question wrong, you'll get your answer wrong. It's like a torchlight. If you shine your torchlight at the right spot, you can see in the darkness. If you shine the torchlight in the opposite direction and you look down there, you can't see a thing. So that moves us to tip number 15. This is one of the best techniques available, tip number 15. Set the stage for the question, then pop the question. Garner calls this the PAYNE approach, P-A-Y-N-E. He says, very useful device for stating a two-way question. Two-way meaning it has got a yes or a no answer. On a complicated issue is to make an introductory statement that sets the stage for the question. He gives an example. It's a question on income tax law. I'm going to read the question and tell you how confusing it is. Bear with me, please. Whether the owner of coupon bonds should include in his gross income the amount of coupons which he detached and gave to his son several months before the maturity. This is a tax question. The question asks whether he has to pay tax. Look at the way the question is drafted. It's boring and confusing. Now look at example number 3. Set the stage, pop the question. Listen to this question. The taxpayer owned coupon bonds. Full stop. Several months before their maturity, he detached them and he gave them to his son. Full stop. He retained the bonds themselves. Full stop. Is he relieved of income tax on those interest coupon? Of the two, don't you think example number 3 is clear? Ask questions like that. Set the stage. Pop the questions. The judges will get it. Tip number 16. Have you heard of this phrase, verbal diarrhea? You open your mouth, a flood of words come out and fall and nobody knows where you are going. Use as few words as possible. That's tip number 16. Limit the question to 75 words. If you can do it in 30 words, it's brilliant. But don't confuse simplicity for lucidity. If you look at a pool of water and you can see it's 30 feet deep and you can see the bottom, that's lucidity. You don't lose depth, but you also have clarity. But if you just skim at the top, that's simplicity. Don't confuse lucidity for simplicity. So this is what Garner says. The court has not lived with your case for several years. You have a great deal of information to convey in a very limited space and time. It is critical that you formulate and reformulate the question presented until you have provided a favorable, accurate, succinct characterization of the issues involved in your case. The takeaway here is formulate and reformulate. Keep pairing the question until you get to the bone. Do it again and again and again and again until it becomes clear. I'll give you an example. This is example number 4 in my article. Where a civil court has acquitted a litigant of fraud, can the Court of Appeal reverse the finding and to make a positive finding of fraud against him, having regard to the rules laid in Ariel versus Demarel? 40 words. You ask the question, you give the case law, you ask them which way they have to go. 40 words. Tip number 17. Simplest words are the best. Keep everything simple. Okay, I'll give you an example. Can aggravated and exemplary damages be awarded simultaneously? The words at the same time instead of simultaneously could have been used, but that requires use of 3 extra words. Simultaneously cuts down 4 words into 1. It's an easier read, it deepens understanding, it's less tiresome to the eyes, less is more. Tip number 18. Pepper your questions with lynchpin cases. A question without case law or relevant statutory authority is boring. It's uninteresting. It is liable to be ignored. Therefore, you must embellish the questions with cases. Not any old case. It must be one that has changed the flow of case law. Choose a question with some essential components. I'll give you a number of examples. As a general example, let me say this to you. In view of case A, is the proposition, which is a question you're asking, any longer good law? So, another way of saying that is, has the white test in case A to the effect that XXX, your question, now been narrowed by case B? So let me give you another example. Can an insured under a fire insurance policy do X? Having regard to the decision of the House of Lords or the Supreme Court in case A and the latest decision of the UK Supreme Court in case B. This really happened, you know. Now, let me give you another example where I fill in all the gaps for you, these X's and Y's and A's and B's. Example, in view of the House of Lords decision in Rooks versus Barnett, Castle versus Broom, and the Federal Court decision in Malaysia in Bank Bumiputra versus May Perkayuan, as a matter of general principle, may aggravated damages be awarded for breach of contract? 57 words. Immediately the Federal Court will be intrigued. The judges will realize that what is being asked is a pure question of law, that is going to change the general law. Nobody is talking about a finding of facts. There is no contest over any evidence. One judge called it the killer question. I call it the shining question. It stands up by itself, it sheds light, and they can see it's bright. Their eyes will be drawn to it. It's a pure question of law. Pure. No facts, no nothing, no conditions, no grandmother stories, no blah, blah, blah. Straight to the point. Tip number 19. If you use statutory authority, then demonstrate that there is an uncertainty. See example number 5. This concerns the Street and Drainage Act, which I did many years ago. For example, I say, does Section 95 of the Street, Drainage and Building Act 1974 render every local authority immune from any suit for breach of contract or for negligence? Good question. 26 words, but it's boring. Let's set the scene and pop the question. Yeah? Let's try. A local authority enters into a contract. The contract requires it to perform certain duties under the Street Drainage and Building Act 1974. The local authority breaches those obligations. It is also guilty of negligence. Would Section 95 of the Act make it immune from any suit? Is it protected? Which is better? The question is all the elements, the statutory provision, the drama, the suspense, how it helps a local government escape liability. So there is a general principle lurking about like a whale under the sea. And the answer to it definitely will benefit the public. Tip number 20. 99% of the lawyers fail here. Keep your submissions to 5 pages. That includes the title, by the way. Yeah? There's a book called The Brutal Simplicity of Thought and How It Changed the World by MC Sachi. If you exceed 5 pages, you will fail. You are dealing with very old judges who are tired, who have many pages to read. If you've written 50 pages, you think they will read? Can you read 50 pages a day? And you've got 14 hearings a day. So 14 multiplied by 50 is how much? 700 pages. You can read that. I cannot read. But if it's 5 pages and they've got 14 cases to read, which one do you think they will go and take out and read first? Yours lah. Winston Churchill was a master of the English language. He said in a letter to a friend, I didn't have the time to write you a short letter, so I wrote you a long one instead. Brevity takes effort. Clarity takes hours of thinking, writing, editing. Lord Denning famously said, I am not a good writer. I am a good rewriter. It is said that he sometimes edited his judgments as many as 40 times. So the moment the federal court judges set their eyes on your question, they will say, there is something here that's troubling us. Let's see what this lawyer has to say. Tip number 21. You must convince the court even before it comes up to the bench. Imagine that. You must get the judges to your side even before they ascend the steps and come into the bench. Your questions have to strike them as unusual while they are rushing through various written arguments in their chambers. It's got to intrigue them. They must get it quickly, clearly. The question, says Garner, should be stated so simply, so clearly, that the judges will grasp it at once. Tip number 22 is related to tip number 21. Long submissions do not work. They can make you feel great. They can make you send your clients a big fat bill, but it will not win you cases. Easy understanding will lead to success. Efficiency doesn't mean the paper with the shortest length. Rather, it means the paper that makes readers the shortest time to understand. So, start in the very first sentence with the problem in this case. Put it right up front. Start early. Don't bury the layers of verbiage and preliminaries. Go straight to your question. Say, the applicant seeks leave on the following questions. State the questions. I have seen many times the federal court judges coming there saying, where's your question? Oh, annexure A. You know why? Submission, introduction, facts. This fellow filed that. He did this. High Court did that. Court of Appeal did that. 5 pages. By the time the federal court reads, it takes them 5 pages just to understand who filed what. You're not interested in all that. What's your question? Get that. Tip number 23. There are certain things you must never do during arguments. Some things, the moment you open your mouth and say, you will fall down. First is, don't bother with evidential findings of evidential points, whether it's in the affidavit or in the application. Avoid it like a COVID-19 virus. During oral submissions, don't go on and on and on about factual or evidential dispute. You want to commit harakiri? Go outside the court and do it. Don't walk into a trap. They will pounce on you. They will tell you what you know. That's a question of fact. We dismiss your application. Thank you very much. Don't go there. Tip number 24. How to argue. Intrigue the judges with the question. Pique their curiosity. Provoke their interest. You know, when they're coming up, they're like this, you know. Okay, this guy is saying this. There's a problem here. I know I read a case in the UK, you know. But you know, they're not going to give you an easy time. They will probe your understanding. They will push you. They will pounce on you. Don't panic. When judges are talking to you, don't tremble like a leaf. Stand up like a lion and be as courteous like Raja Aziz. Answer the question. The more curious they are, the more questions you will get. And the more questions you get, oh, by the way, when they're asking questions, shut your mouth. Don't interrupt. They will say, you know, you are saying, they're doing this. Don't go and masuk dalam in the interstitial spaces and get into trouble. Encourage a conversation. Don't wilt under all the pressure. They're just shaking the tree to see if anything falls. They want to know if the question is of national importance. For example, you remember example 10? A local authority enters into a contract. It is required to perform certain duties under the Street and Drainage and Building Act. The local authority breaches those obligations. Is it guilty of negligence? Can Section 95 protect it? Tip number 25. Comply with the 90-second rule. Don't waste time at the federal court. What you need to say, say in 90 seconds. Go and see the whale hunting movie, The Heart of the Sea. If you cannot get the court's attention at the first throw of the harpoon, the whale will go under the water. You'll never get a second chance. And the whale will come and sink your ship. You know, in the book, Garner says, unfortunately, the judge doesn't have the luxury of time for leisurely, detached meditation. You'd better sell the sizzle as soon as possible, said another judge. There are other techniques. This is not the only successful method. Other lawyers have other techniques. There may be other methods. These techniques have worked for me. I hope they do for you too. Good hunting. Best of luck. Thank you very much. I hope you liked this video. If you did, please click like, please subscribe, and please comment, because when I see your comment and you interact with me, I know you want more stuff like this. I have very little time, then I can spend my time and do stuff like this so that you will benefit. Have a good day. Thank you very much.